Welcome to Southwest Florida Real Estate Update, hosted by local realtors Jim, Michael, and Morgan York of the York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, featuring the leading experts in the real estate field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you for the introduction, Michael. Well, welcome to the show today.
Thank you.
Don,
Thank you, Jim. Appreciate it.
Don, tell us a little bit about yourself for the viewers that maybe haven't seen the show.
I'm an attorney in Naples. I've been a member of the bar for over 30 years. I'm owner in Downing Fry Realty, attorney for 25 years. Ross Title and Escrow, we have 8 employees. We've done 25 to 30,000 closings. Most of my people have been with me. One lady 30 years, another lady 20 years, another one 10 years. So we know how each other works. We emphasize returning phone calls and responding, and we do a fairly decent job.
Well, your staff does an excellent job.
Thank you.
So,
Appreciate it.
Don, we've had some people write in today, okay?
Okay.
Okay, it's sometimes we do this, okay?
Sure.
And this particular person asked, what are the essential elements of a real estate contract?
Law school definition is all the material terms of the contract. You need the parties, the proper parties. You need exactly what the agreement is, the subject matter, whether you're selling real estate or you're going to paint a boat. I mean, what are they doing? The consideration. Now, consideration is a legal term which can be money or it can be a promise to do something. In our real estate contract, the consideration from the seller is the promise to sell, and with the buyer, it's the actual deposit and promise to pay. So those are the essential elements. All the material terms. You need a closing date. You know, the case law over time has added tweaks to what is material. All the terms necessary for a third party like a judge to look at and say, yes, this is what the parties agreed to do. These are the remedies if either one of them defaults. Here's the consideration. We have the correct parties. And in some cases, it has to be in writing.
Does that include all the disclosures that have to be signed also?
No, the disclosures do not have to be in writing. The disclosures in this state are the fruit of a 1985 Florida Supreme Court case that the seller must disclose in residential deals latent material defects. Out of practice, they've come up with written forms, both the Florida Bar and the Naples Board of Realtors. The written forms are very, very helpful because it's clear that these things have been disclosed. There's no question about who said what to whom. You can see it in writing. So, you know, even though something might not be necessary in writing to be legally enforceable, it's a good practice as a matter of proving that it was made, that representation, that disclosure was made. So our seller's disclosure actually goes beyond the latent material defects. It's not legally required to be in writing, but it's the safest way to do things.
Mm-hmm. This other person says, she's asking, who signs the contract first?
It's all strategy. I mean, you're in the sales business. I generally tell people let the other person go first, whether you're the seller or buyer. If you initiate things in most cases, and I would defer to you, frankly, on this. If you don't want to go first, because what if the other side would accept less?
Right.
So whenever you can get the other side to go first, to make the first move, it's a strategic advantage. I think it actually factors into why the house has the advantage in blackjack, for example. Mm-hmm. You go first, and then the house can respond to what card you have.
But typically the buyer puts an offer.
Traditionally, the buyer goes first because traditionally most sales are listed properties, and other agents, cooperating agents who are a member of the multiple listing service, see these properties, and their client might want to make an offer, so they have their client prepare a written offer and submit it to you if you're the listing agent.
Next question is, does the buyer or seller close first?
I guess one way to look at it is we have escrow closings. Over half my closings are through the mail. So I get a lot of, I get the money here beforehand, I get the signed closing statement here beforehand, and then we sit and wait for the seller to produce their documents, and then we exchange. I had a client on the phone this morning who wanted to know officially, because he's from Canada, I believe, officially when he can put his boat in a boat slip. He's buying a boat slip. I said, as soon as we have your money, we give it to the other side, and they give us the assignment of the boat slip rights. It technically doesn't even have to be recorded for him to have legal ownership of it, but the recording part of it gives notice to the whole wide world, so you don't get the dishonest seller who might try to sell it to a second person or a third person or a fourth person. So the recording is not a legal requirement, but it protects buyer number one.
And if there's a person who has a mortgage, usually the buyer signs last.
The buyer, we have until 11:59 under our contract, the neighbor contract, to close. Rarely do we push it past close of business hours, but once in a while we have to do that. Sometimes our lenders from California, for example, we don't get everything until late in the day.
Right.
And in that case, the buyer has to sign last. They have no choice. Oftentimes we'll reach an agreement that the documents are coming in from California, we'll disperse in the morning. And that's usually fine.
And this next one question is a sales agreement binding?
It was done correctly, yes. Absolutely. But binding is a word like reasonable. Again, take our NABOR contract. Is it binding? Sure. There's a remedies clause in it that says if the buyer fails to close, the seller can claim the deposit as their exclusive remedy. But if the deposit is $100, it's only $100 worth of binding.
Right.
And on $1 million deal, it's really not that much of a tie. But from the buyer's perspective, the buyer can actually sue the seller for specific performance. That generally is binding. It's an equitable remedy, which means the court could actually say no to the buyer, because real estate's unique.
Right.
And the buyer may have made plans, they might have movers, they could have done a lot of things. And in my experience, generally the buyer gets the specific performance. I've never seen a seller get it.
This last question is, what's the difference between using a title company and using an attorney?
It's form versus substance. You can have a title company like mine that has an attorney, i.e. me, and functions exactly the same as a law firm. You get the legal expertise. It just happens to be under the corporate structure of a title company. People form title companies for various reasons, but the real difference is not all title companies have attorneys, just some.
That's right.
Not all title companies have equal experience. Frankly, not all lawyers have equal experience. So my advice generally is to look beyond the facade of the title company, see who is there, have they been there a long time, do they have a lot of experience, regardless of whether it's a title company or a law firm. I have one right now where we're having difficulty with the attorney on the other side. So I, of course, go on the internet and look the person up and find out that the person does 50% litigation. I said, oh, well, that's why this thing is a nightmare. Litigators are aggressive.
That's right.
Fighters, they like to win. That's what they're supposed to do. When they come into a transactional part of the law, that carries over. I have to look at things differently as a transactional attorney.
And what's the difference, this last question was, what's the difference of if they are buying a property in New York versus Florida using an
Oh, that's a good one. I have family in New York. I have cousins who do real estate closings who are in major title companies in New York. New York, New Jersey, Connecticut, time is not of the essence. In New York, the attorney drafts the sales contract. They don't have a pre-printed form like we do. Nothing closes on time in New York, nothing. The typical closing, as explained to me by my cousin who's with a major national underwriter, is you have everybody around the table. You have the buyer's lawyer, the seller's lawyer, the bank lawyer, and a title company. And then they argue about minutia.
Right.
And then they storm out and they close 2 weeks later. My third son's mother and father-in-law were selling their home in Long Island, New York, and they're trying to buy a condo down here in Florida. My son's mother-in-law is a retired school teacher in Long Island. I had to point out to her, her Long Island property is not going to close on time. I said, I will guarantee it, it's not going to happen. It was 2-3 weeks late. Lawyers in New York, and I can say this because they're my cousins,
Right.
they're different. They're different. In Boston, I'm from Boston, you know, they have offer sheets and then they go to P&S.
That's right,
The
yeah.
offer sheet is like a letter of intent.
Mm-hmm.
You know, every place is different. That's part of the reason why when we have a closing down here, we find missing fixtures and things of that sort because they do things differently in every state in the country.
Right.
Never mind Canada and the UK and France and Germany and all the other countries we have to deal with. They're all different.
Well, Don, thanks for coming on the show today, and I've learned a lot, and I'm sure the people that wrote in today wrote a lot, and we'll see you
Thank you,
next
Jim.
month. Okay?
Appreciate it.
Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.